Hey everyone, Rob Ryder. It's Sunday, August 18th, 2013. A lot of what I'm going to be reading out of is coming out of this right here. It's called The Essential Meaning of Executive Power by Krishna Prakash. Anyways, write that down. If you want to find it, just go on Google. Google The Essential Meaning of Executive Power. And, light bulb moment. We're going to the wrong offices with everything that we do. Whether it be to the courts because we're fighting a court case, or trying to bring somebody to court. Things at the county clerk, trying to get them recorded. Register of deeds, tax man, so forth and so on. Because what we need is to use our executive power to have the law executed. Right? We're going to execute the law by having an executor go carry it out for us. After all, we are the executive. So, the essential meaning of executive power. Get your copy today. Anyways, what do we want to talk about? So what is executive? Government. The power in the government which causes the laws to be executed and obeyed. It is usually confined into the hands of a chief magistrate. The power in government which causes laws to be executed and obeyed. That's what we're supposed to be doing. The President of the United States is invested with the authority under the national government, and the government of each state has and the governor of each state has the executive power in his hands. So what they've done with these constitutions is the power that we would have had anyways, because we agree to be a citizen. Well, now we've delegated our power to the constitutional officers in the Constitution. The officer in whom is vested the executive power is also called the executive. That would be ye, as in you, plural you. Because to vest, to give an immediate fixed right of present or future enjoyment of an estate is vested in possession when there exists a right of present enjoyment, and an estate is vested in interest when there is a fixed right in future enjoyment. Either way, we have vested in us an estate, and we have the right to enjoy it. But what we've done is through power of agency, law of agency, whatever, sign some piece of paper, we have them managing it for us. We need to go back to the executive and say, I don't need you to manage my affairs any longer. I may want you to administer them, but you'll do it under my orders and no one else's. I don't need a conservator. I don't need a guardian. The Constitution of the United States directs that the executive power shall be vested in the President of the United States. Governor, the title of the executive magistrate. See, executive magistrate. Interesting, because we're supposed to lay our complaints before a magistrate, but it really never says who. In each state and territory of the United States, under the names of the particular states, the reader will find the duties of the governor of each state. So, go look up your governor for your state and find out what their powers are. The executive is the part of the government that has sole authority and responsibility for the daily administration of the state. The executive branch executes the laws. The executive branch executes the laws. For a third time, the executive branch executes laws. We need to be going to the executive branch, not the judicial, not the legislative, not the county clerk or all these crazy people. The executive branch. And here, let's just look at a couple to see why that is. Also, now the executive branch, has the power to govern. That's the other thing. Governing means to rule, which means to be able to execute the law. So like here in a little county we have in Michigan called Alpena County, the County Board of Commissioners is the governing board and policy making body. So this both has the government to be able to execute the law and the legislative policy making body. And as we'll see, Cam is the chairman of the board. Now, Tom talked to Cam this weekend. Tom and Rich had lunch with him on Friday. And Cam's just a hard-working guy. He lays pipe for a living. He came to lunch. It looked like three guys just came off the sawmill, right? So Cam didn't drive up in a Ferrari wearing a three-piece suit. He's working for a living. And one of the things Tom says, well, you understand you're the most powerful man in the county. And Cam said, I've been told that before, but I don't really see how that is. And as Tom found out, Cam doesn't know a lot about the law. Right? He's not learned in the law. It doesn't mean he doesn't know right from wrong, which is really all he needs to know. But he's not learned in the law. But one of the interesting other things that Tom asked him was, well, do you have the power to issue subpoenas? And Cam said, I don't know if I do or not, but I know I can go into any office in the county and get any record there is. I'll say again, he can go into any office in the county and get any record there is. That may be good to know. I think that's the guy you want to talk to. He can go into any office anywhere in the county and get any record there is. We may want that on our side, right? Because we want them to subpoena the records and bring them forward to be examined to see if there is a sworn complaint against you. Or who is it that has your birth records? How about we subpoena those, Cam, and bring them to the office? And let's get this figured out, whose property that is. And how about we tell Cam that we want to terminate the relationship with the state being our guardian or conservator? We'll take it from here. We'll work out those words later, but that's kind of the idea. All right, now, in another county, so Cam would be sitting over here in this Board of Commissioners, and it's a small enough county, Alpena is, small county, not very many people. They don't have a chief executive, but Bay County does. And in Bay County, as you can see, they have a county executive, and all the offices answer to the county executive. And the great thing is these are all upper lower case, proper case offices. It isn't that all capital letter office you walk into when you walk into the county building. Right? Those are all the elected officers, and they're not even on this one here. We'll see that they don't really touch anything. But there's the county executive, and here's the Board of Commissioners. And, they have some authority over here. But the county executive is over all of the offices. And another interesting thing that Cam said was, talking along those lines, he said, yeah, we had a court case here not too long ago. Well, in his tenure. Now, he's been there a couple of terms now, so I don't really know how long ago this was. But there was a question from, it was either the county clerk's office or the circuit court clerk's office, that the employees of that office worked for them. Let's say it was the county clerk. I don't know that it was. I'm going to say it is county clerk. And that the employees of the county clerk's office, worked for the county clerk. And it came back from the court case that, no, they worked for Cam. And the attorney that the county had hired for Cam even told Cam, you realize you had the power to fire those people. Talking about the officers. He didn't know that. So there's no question that the people who work in these offices work for the county executive. They don't work for the officer over the elected officer. They work for the county executive. And the county executive works for the chief executive of the state. This guy here is charged with executing the laws of the state, and it's lowercase state, and so that would be your law. It's his job to execute your law. Now, we could use the laws of Michigan and go say, look, it says here in this law that a sworn complaint has to be attached to a criminal case. Go get the case and go find me the sworn complaint. If there isn't one, somebody's committing fraud. Execute the law. All right, now let's compare this one, Bay County, to Maricopa County, which is a little bit busier to look at, but the main thing I want to show, see these boxes up here, none of these people are attached to anything. Constables, county attorney, assessor, These are all elected offices. But here's the board, and it has a chairman, and then it has a county manager. But it's the county manager that's attached to all the offices. And so Bobby emailed Maricopa County and asked them, who's the chief executive officer of the county? And they said, county manager. So it just sounds like that's the place that we should be taking our complaints, petitions, orders, whatever it is, to have carried out. Not to the judicial branch. Here's the judicial branch up here. It isn't attached to anything. Now, some judges are elected and other ones are appointed. And Bob in Massachusetts found out this about a week and a half ago when he was in court. And he asked the judge, he said, well, who delegated you your authority? Not meanly, he said it was a good, that the judge was very cordial and knew that Bob had been studying and, was answering questions, but he wasn't giving answers. But when he was asked, who delegated him his authority, he said the governor did. 2 terms ago, or 2.5 terms ago. Right? He was appointed by the governor. Okay, so I got those out of the way. So I don't have to worry about those anymore. Because this is why this all gets important here in just a second. So the executive is the part of the government that has sole authority and responsibility for the daily administration of the state. The executive branch executes the law. That's the important thing. They execute the law. The division of power into separate branches of government is central to the idea of separations of powers. In some countries, the term government connotes only the executive branch. However, this fails to differentiate between despotic and democratic forms of government. In authoritarian systems, such as a dictatorship or absolute monarchy, which is really what we are, where the different powers of government are assumed by one person or a small oligarchy, the executive branch ceases to exist since there is no other branch which to share separate but equal government powers. The separation of powers is designed to distribute authority among several branches in an attempt to preserve individual liberty in response to tyrannical leadership throughout history. The executive officer is not supposed to make laws, that's the role of the legislature, or interpret the laws, that's the role of the judiciary. So we don't make them and we don't interpret them, but we do enforce them. And so how are you going to preserve your individual liberty? You're going to go to the executive officer who's there to carry out the law and tell him to do so. The role of the executive is to enforce the law as written by the legislature and interpreted by the judicial system. Responsibility. The top leadership role of executive branch may include head of state, often de jure leader, the chief public representative and living symbol of national unity. Head of government, often de facto overseeing the administration of all affairs of the state. Right? So de jure could be your proper case name and de facto could be your uppercase name. In a presidential system, the leader of an executive branch is at once the head of state and head of government. In a parliamentary, cabinet minister responsible to the legislature, while the head of state is largely a ceremonial monarch or president. I tend to think we're almost more under a parliamentary system because we are under the laws of England. So you see, it just depends on what level of the government you're talking about. But if you put you as the citizen on top of the Constitution, then you're the executive, and you have officers like a chief executive officer that's supposed to execute your law. Executive, relating to the execution of laws, the conduct of public and national affairs, belonging to the branch of government charged with such powers as diplomatic representation, superintendence of execution of laws. Everything about this is about executing law, right? We're trying to get laws executed. Now, let me go back to this here. Is this one I had it on there? Here's a county executive, here's a prosecuting attorney, right? So the attorney's office is part of the executive. And you would think that these are the places you could go to, these down here, to have your orders executed. But you can't. You have to go to the chief executive of whatever the size territory you're talking about. So now the rest of this comes out of that book I was talking about. This comes out of this, I already closed it, about executive powers. Evidence from the 18th century reveals the essential meaning of executive power. The European political theorists of the era declared that executive power was the power to execute the laws. In America, state constitution political commentators employed this basic definition. Debate at Philadelphia and state ratifying conventions also confirmed this meaning, with framers and ratifiers repeatedly observing that the president could execute the law by virtue of the executive power that comes with the office. Finally, after ratification, statesmen from all three branches understood the executive power was the power to execute the laws. And so, what we have is, let's say down here in this prosecuting attorney, he's got a lot of assistant prosecutors who are bringing these cases into court as the executive branch, saying that you've done some kind of crime. But into an all capital letter court that would be up over here, right? The 18th Circuit Court for whatever, right? Or we just want the upper lowercase circuit court. That isn't where it's coming to. It's going into some court that isn't even on this piece of paper. Well, he's part of the executive, right? So we take our complaint to the chief executive, and when they go and find out that this guy has brought fraud upon the court, the county executive has the power to deal with him. He doesn't need to get anybody's permission. Because the Constitution establishes the executive power is his, the Constitution authorizes the president to execute any federal law. Now, what is a lowercase federal law? I don't know what that is yet. But the Constitution authorizes him to execute them. This constitutionally sanctioned power to execute the law explains why the president is widely regarded as an executive, an official who executes the law. Moreover, the executive power also enables the president to control other government officers who execute federal law. In other words, he's over all the other officers executing federal law. Because only the president has the executive power, others who execute the law derive their authority to execute not from the statutes that creates their office, but from the president. All the power flows back to the president. This feature of the executive power reveals why the president is properly referred to as the chief executive. Other officials who execute laws are executive officers by virtue of the law execution role and because they are chief executive's means of executing the law. Meaning, this county executive, this county manager, this chairman of the board, because it is also a governing body, hate when that happens, are the ones who can execute the law. The states hobbled the executive power and disregarded somebody's maxim. The state legislature seized executive authority from royal governors and wielded that authority themselves. Then most states adopted constitutions that, although they paid lip service to the separation adage, nothing less made their executive powers appendages of the legislature. So that's what the states did. They wanted to have a weak chief executive. They wanted to make you weak. With notable exception, executives were appointed by the legislature. Faced with term limits, could not appoint executive officers, and lacked veto authority. So that's what it was before, right? This thing about veto authority is important. And if they can appoint executive officers, yeah, good or not, but the veto thing is. And faced term limits. To top it off, the few constitutional powers they did enjoy were often subject to legislative alteration. Little wonder that experience under state constitutions led many to decry legislative supremacy and executive impotence and laid the groundwork for the resurgence of executive power in the federal Constitution. As Blackstone, Jefferson, and others affirmed, the English king possessed the executive power to execute the laws. With such power, he superintended law execution in England and its colonies. In the American colonies, the king's royal governors were his direct representatives and chief law enforcement officers in the various provinces. Indeed, numerous charters, orders, and other royal instruments spelled out the governor's law enforcement role. So really, it's no different today. We're the English king, and the governor is our direct representative and chief law enforcement officer through the executive branch. With the revolution, the independent sovereign states assumed, and assume means, color of law, the executive power of enforcing the laws. The state legislative bodies initially assumed complete legislative, executive, judicial authority, often forming committees of safety to exercise executive functions. Yet they caused all sorts of problems. I wonder how that could have been. According to somebody, the attack in the assemblies emerged most fully in Maryland. One county instructed its delegates to the Maryland Convention that the legislative, judicial, executive, military powers ought to be separate, and that in all countries where the power to make law and the power to enforce laws are vested in one man or in a body of men, a tyranny is established. Well, that's pretty much how it works. In all countries where power to make laws and power to enforce are vested in one man or a body of men, tyranny is established. Well, that's pretty much how it is right now. Similar comments were voiced, right? It should be many men, vested in many men. It's not just vested in one man, it's vested in many men, all of us. Similarly, comments were voiced in other states because citizens grasped the essence of these powers. There was no need to define them. Of course not. We're not going to define anything. We're not going to define that we're going to get you to give us a piece of paper saying that you want us to administer your estate. And of course, part of that administration is to make sure it makes as much money as possible, which means we need to keep you from having access to it. That's what they're doing to us right now. Recognizing that committees of safety could not provide stable, energetic law execution over the long term, states adopted constitutions with nominally separate executive. Now, what is nominally? Existing in name only, not real or substantial, connected with a transaction or proceeding in name only, not in interest. Nominal executive, a person who heads the executive branch but does not have the power to execute major and important decisions. Normally a king. They adopted constitutions with kings as the separate executive, but not having the power to execute the laws. Real executive, a leader, right, which is different than a person, a leader who holds real power, makes important decisions for the country, like the prime minister. Right, and I think our governor is the same as a prime minister. Right, the highest office below the king, and we're the kings. Though these titles varied as did the size of the executive branch, the executive possessed the essential law execution power. 3 states granted variations of executive power to one person. New York governor had the supreme executive power and authority. New Jersey simply the supreme executive power. Right? So they have the power of the supreme executive. That's why we need to go to them, because they have our power, because we're a citizen of the state. In Pennsylvania and Vermont, the supreme executive power rested in a governor and an executive council. All right, so that would be something like this one. Where Cam is sitting as the governor, and here's his executive council. That's one way they could do it. That's how they did in Pennsylvania. New York, right? That's more like, well, like this right here, county executive, supreme executive power. Delaware, yeah, granted there executive powers, along with a grant, executive specific authority, along with a general grant of executive powers. Besides the grant of executive power, there were other signs of executive control of law enforcement. Some constitutions referred to the executive power as the chief magistrate or supreme executive magistrate. It's the magistrate we want. Chief magistrate, the supreme executive's magistrate, right? He's our magistrate. Others enjoin that the executive take care that the laws are faithfully executed to the best of his abilities. It's up to us to make sure that they're faithfully executed. One even had his chief executive take an oath that explicitly referenced his law execution. From the weakest to the strongest, they were to execute the laws. Although the outer reaches of their power were often in doubt, the executive's law enforcement role could not be questioned. Indeed, as Gordon Wood notes, there are many who sought a chief executive that could do little more than execute the law. For instance, one gentleman there said, "For the sake of executive, we must have a magistrate, but the magistrate must be solely executive. Not in the judicial, not in the legislative, in the executive." Indeed, Virginia characterized the governors of the period as wholly executive of political laws of state. In other words, these governors generally could do little more than execute the law. Notwithstanding the voices demanding that three powers be kept separate, and despite the grants of executive power, distrust of the executive, the nominally separate executive king, being you, was far too ingrained to ensure proper separation of powers. In the minds of many, executives were associated with agents of the British Crown that had battled the local assemblies. A Delaware Whig reflected the lingering suspicion from colonial past: the executive power is ever restless, ambitious, and ever grasping at increase of power. This vicious tradition of distrust yielded constitutions constructed to ensure executive subordination to the legislature, make you subordinate to the legislature. Despite their formal powers to execute the laws, governors simply could not be responsible administrators for a number of structural reasons. First, though, all chief executives were vested with executive power or the equivalent, and many states and executive power was exercised at the sufferance of the legislature. Patience, endurance, especially of pain or distress, suffering, sanction or permission applied or given by failure to prohibit, tacit consent, tolerance. In particular, many of the executive authority could be exercised only according to the laws. As Charles Thatch pointed out, language like this fairly invited legislative interference, for one could argue that the Constitution left the executive powers at the mercy of the legislature. Under such constitutions, the executive merely exercised default powers, but that could be withdrawn or reshuffled at will. Not surprisingly, such authority was not only used to direct the executive in all matters, but also to effectively strip away the executive power entirely. Took the power from the people. The second reason for legislative dominance was the state executed lacked veto authority. The absence of veto is such with which to defend executive prerogatives from rapacious assemblies gave new meaning to the phrase parchment barriers and made these executives paper tigers. Right? We don't have veto authority. Those few state executives that enjoyed the veto were appreciated as driving their power because it helped safeguard the executive powers and acted as needed check on assemblies. For instance, Massachusetts veto ensured a due balance may be preserved in three capital powers of government. Okay, so one of the things we're looking for is who has veto power. And as it turns out, in Michigan, Michigan Compiled Law 45.561, the county executive has veto power. State Administration Board, governor has veto power. Third, the Constitution, and I believe a mayor has veto power also. I didn't put him on here, but at a city level, a mayor has veto power. Third, the Constitution assured executive subservience in a number of other ways. 7 of the state constitutions left the selection of the chief executive with the legislature, an appointment. And that is what we have in Maricopa. Tom Manos, the county manager, he was appointed to the office by the Board of Supervisors. Moreover, most chief executives had 1-year terms and were term limited. The combination assured an executive a short legislative leash, and with a short time horizon, further, the Constitution often splintered the executive authority. So here's another thing, right? In this one, they've appointed this guy Tom Manos, but this chairman, he also may have certain powers, and Tom and this guy both may need to go together, put a seal on paper. That would be the 2 justices of the peace on an instrument to get like a subpoena or something issued. This guy here is going to look for probable cause, and if he has it, he'll take it to Andrew. Andrew and him will both seal the paperwork, issue a subpoena, because Andrew can issue a subpoena. He does have that power. We've seen that already. And what would the subpoena be for? Well, by what authority do they bring this charge? Or the subpoena would be to show cause why the respondent should not be held in contempt of court for not providing a sworn complaint. If he doesn't show up, he is in contempt of court. The nominal chief executives often lacked appointment and removal authority. Again, nominal means in name only. So the king lacked appointment and removal authority. We don't have that authority, and thus had difficult time controlling other executives. Without such authority, the executives found it difficult to be responsible administrators for those statutories created to help execute the laws were under no real obligation to heed the chief executive, right? Because we can't remove anybody. They really wouldn't have any reason to do what we say, but this guy can remove any of these people. In Alpena, Cam was told in a court case he can actually remove, not only do everybody in the county offices work for him, and he has access to all files anywhere in the county, but he can deal with the elected officers. Other constitutions created a plural executive, whereby the chief executive often was required to seek advice or approval of an executive council. Right, so that's what this could be. Tom has to seek approval of the executive council. Because it's Andrew who can actually issue the subpoena. In at least 2 instances, the executive was a council. The executive, as in one, the executive was a council. Okay, so that could be this one. The executive was a council, is a council. He is the council. You don't need to go ask anybody, if that's what that means. When executive power effectively was distributed across many independent executives, the executive branch as a whole was no match for the legislature. Such a feeble and fettered executive could neither be energetic, independent law enforcers envisioned by Locke and somebody, nor the responsible superintendent of law and execution described by Blackstone or de Lama. Almost alone, New York's executives suffered few, if any, of the problems associated with the executives elsewhere. And Michigan adopted the form of New York, and they became a state. Vested with the supreme executive power and explicit duty to execute the laws faithfully and share in appointments and the veto, and appointed by the people, the governor came equipped with considerable authority. All the isolated principles of executive strength and other constitutions were brought into a new whole. Because the governor could withstand legislative attacks, it stood as an example of the federal Constitution. A few lessons can be gleaned from the state constitution. First, these early constitutions were generally the products of ignorance, bias, and fear. In his notes on the state of Virginia, Jefferson admitted that we were new and unexperienced, new group of Masons in the science of government and drafting the Virginia Constitution. Much later, Jefferson wrote that prior to the Revolution, all were good English Whigs. They all had slaves, cordial in their free principles, and they're jealous of the executive magistrates. Yeah, we want to have all the power. We're going to have slaves. We're going to take your property and minister it for you. We're the government. We're here to help. These jealousies were very apparent in our state constitutions. James Wilson likewise asserted that while the people treated the executive and judiciary like stepmothers because of their former association with English connection, the people confidently ceded power to the assemblies. Silly people. Second, the inexperience, bias, fear resulted in constitutions that enshrined executive weakness and legislative supremacy. Jefferson wrote that because no proper barrier separated the three powers and because all other branches were dependent on reappointment and salary, all the powers of government, legislative, executive, and judiciary result to the legislative body in Virginia. Okay, so you get the idea, right? Executive power. Constitution, executive enjoyed veto authority. That's beautiful. The Constitution executive is selected by electors. Got that too. And they enjoy a 4-year term. The Constitution executive is unitary. Unlike default state executives, Constitution, many executive powers cannot be modified by ordinary legislation. So I guess the Constitution executive is unitary means it's a 1, right? So, this county executive in Bay County, he is elected. It's an elected office. So he is the 1 at the county level. But his office is under the chief executive of the state, right? So if you can imagine, you got the governor there, and how many counties do you have? And each one of them has a county executive, or whatever their form is, but whatever that form is, the power that they're controlling is the power that was given by us to the governor, with us on top of the governor. And they're tasked with executing the law. Now, let's look at something here. How do you tell who these guys are? Public funded health insurance. Okay, a county with a county executive who is both the chief executive and chief administrator. So that's interesting. Right now we got to worry about, is the county executive both the chief executive and chief administrator? Because if not, if he is, then he has to approve whatever this is. The main thing is, it said that there is both a chief executive and chief administrator. Now, it could be that he's both. It could be that he's a manager. He has one. He's the administrator, and he has to go to the chief executive, who's the sitting on the board. And the two of them together have to sign off on the paper. Now, Emergency Management Act. Now, here's where another guy is going to get involved. Who is the chief executive official? In the case of a county with an elected county executive, it's the county executive. In the case of a county without an elected county executive, the chairperson of the county of the Board of Commissioners. And that's what we have here. Don't have a county executive, chairman of the board of the commissioners is has the executive power. Or the appointed administrator designated by appropriate enabling legislation. We got to add an or here. Who's the or? Emergency Management Coordinator is the or. They exist. I kind of wonder if the Emergency Management Coordinator is actually a federal level, working as from the President of the United States Executive Office and not the state office. Because we are in a state of emergency. I believe we've been in one since, 1865, when Lincoln started to write executive orders, because my understanding is you can only write executive orders under a state of emergency. And so us having an emergency management coordinator would make sense. And it says here, the county board of commissioners of each county shall appoint an emergency management coordinator. So there you go, Tom and Rich. Ask Cam, who is the emergency management coordinator? In the absence of an appointed person, the emergency management coordinator shall be the chairman of the county board of commissioners. So either they have appointed one or he has both powers. Right, because this is management here. Okay, because, what were we talking about? We could have it, well, it's not on this page. An administrator. Right, administrator could be management. Who's managing our accounts? In the absence of appointed person, the emergency management coordinator shall be the chairperson of the county. Okay, the emergency management coordinator shall act for and at the direction of the chairperson of the county. Shall act for the chairperson of the county board of commissioners in the coordination of all matters pertaining to emergency management in the county, including mitigation, preparedness, response, and recovery. Shall, so he can either act like he is the chairperson of the county board of commissioners, or he can do it at the direction of him. In counties with elected county executive, the county emergency management coordinator may act for and at the direction of the county executive. Pursuant to the resolution adopted by the county board of commissioners, not more than 3 adjoining counties may agree upon and appoint a coordinator to act for a multi-county area. So now you could have this appointed coordinator acting for up to 3 counties as the county executive of those 3 counties. If the county board of commissioners appoint a coordinator to act in a multi-county area. So question is, how do you know if you have one? Well, you go ask the chairman of the county board, because they are the ones who are supposed to have appointed him. Election of county executive, what was this about? Except as the method of selection of chief administrative officer or an elected county executive, the veto power of the chief administrative officer or county executive, then, okay. So the question comes down to the selection of the chief administrative officer or the election of a county executive. So it sounds like the chief administrative officer could be appointed. All right, so we got chief administrative officer. We have emergency management coordinator. We have county executive, and we have chairman of the board commissioners. What we need to do is identify who's filling all those roles, and we'll pretty much know who the executive is within the county, I believe, for both state and federal issues. A county manager or county executive shall enforce all orders, rules, and ordinances of the board and laws of this state required to be enforced by his or her office. That's why we want to find them. Appoint, supervise, and at pleasure remove heads of departments and other elected officials. Oh, other than elected officials. Excuse me. The appointment of head of departments shall require the concurrence of a majority of the county board of commissioners. Now, but they elect our officers, not officials. So I don't know if that makes a difference or not. Do we have any elected officials, or are they elected officers? Is that the reason the word is different? We'll go back to Cam, make sure. Cam, are you telling me you can get rid of the county clerk? Right? Bonnie Friedrichs, you could fire her? I'd like to know. Audit all claims which are chargeable against the county. Okay. And just one more. That's on power. as compared to authority. So power is the right, ability, authority, or faculty for doing something. Authority is permission to do an act which the grantor himself might lawfully perform. So we've given somebody else the authority. We were the grantor, and we might ourselves lawfully perform it. A power is an ability on the part of a person to produce a change in a given legal relationship by doing or not doing a given act. In a restricted sense, power is liberty or authority reserved by or limited to a person to dispose of real or personal property for his own benefit or benefit of others, or enabling one person to dispose of an interest which is vested in another. So we could be doing it for our benefit, we could be giving it away as a gift, or we could enable one person to dispose of the interest that I have that's vested in me. And that's what they're doing. They're disposing of the interest vested in me. Authority, which is permission, which is different than power. Right to exercise powers, that's what the authority is. But who has the power? You have the power to implement and enforce the laws, right? They're our authority, so we're going to give our power of authority to them to enforce the law. Often synonymous power, the power delegated by a principal to his agent. That's where that power, that law of agency comes in. Power of an agent to affect legal relations on principle by acts done in accordance with the principal's manifestation of consent to agent. Show me where I've given them any authority. I don't have a contract with them. Opinions on lower courts or of, reference to the precedential value to be accorded an opinion of a judicial or administrative body. A court's opinion is binding authority on other courts directly below it in the judicial hierarchy. Opinions of lower courts or courts outside the hierarchy are governed by the degree to which it adheres to the doctrine of stare decisis. Legal power or right to command and act. So what this means to me is we wonder why they don't follow Supreme Court opinions and so forth. Well, because a state court isn't in that hierarchy. That's what I think that means. Legal power, a right to command or act, the right and power of a public officer to require obedience to their orders lawfully issued in scope of their public duties. We're going to give them legal power. In the law of agency, such authority as a principal intentionally confers on an agent. Now, somebody was in court not too long ago, and they asked the judge, "Where'd you get your authority?" And he said, "You ever hear of the law of agency?" Okay, let's pay attention. In the law of agency, such authority as a principal intentionally confers on the agent. So who's our agent? I'm going to say it's the county executive. Through the state, through the chief executive officer. And so if we want to change the relationship of us being residents to being citizens, we need to go to the chief executive, who will then go to the chief executive officer or office of the chief executive, being the state, to change the legal relationship that we have with them now, because it will be by our will. It's the only branch that can execute the law. And you have to go to the chief. You can't go to the worker. So, in the law of agency, such authority as principal intentionally confers on the agent, or intentionally or by want of ordinary care, allows an agent to believe himself to possess. Either we did it intentionally or we didn't care, and now the agent believes himself to possess. Well, let's go set the record straight. Stare decisis, to abide by or adhere to, decide cases, right? So are they going to follow it or not? Depends on how they feel. Agency, relation which one person acts for or represents another by landlord's authority, either in the relationship of principal and agent, master and servant, that's where we want to put them, or employer or proprietor and independent contractor. It also designates a place at which business of company or individual is transacted by an agent. So what agency is transacting our business? the relation, now this is the good part, the relation created by express or implied contract or by law, whereby one party delegates the transaction of some lawful business with more or less discretionary power to another, who undertakes to manage the affair and render to him an account thereof. Petition for an account against your all capital letter name. And find out who's managing your affairs and say, okay, I don't need any more conservators, I don't need a guardian, I'll take it from here. Agency is the fiduciary relation which results from the manifestation of consent by one person to another that the other shall act on his behalf and subject to his control, and consent by others so to act. So they take an oath to have this fiduciary duty. Now, Roe told me she tried to get the oath of the emergency management coordinator in her state, or her county, and her county. He wouldn't give it to her. Wonder what that was all about. Okay, and then just more on power, where it comes from. Derivative power, which is usually known by the technical name of power, is an authority by which one person enables another to do an act for him. We given somebody our power. It's still our power. We just have given it to them. And because we're not going to the right office to enforce our will, right? You're going to lose in court. You can't go to the county clerk. You can't go to those places. You have to take it through the executive, and he'll get it done. He's the one that has access to all the files. We're going to figure out what to use that for. Power derived from the doctrine of uses. This may be defined to be an authority enabling a person through the medium of a statute of uses to dispose of an interest vested in either himself or another person. And that's what we did, right? We have an unexecuted second use. In a use, which is a trust, a true trust, the trustee and the grantor would both sign a contract. And if you're the grantor and put the property in a trust with a trustee, then where is the signed contract for him, from him? We don't have one. What they're saying is you gave it to us as a gift on a unilateral contract. So they're using an unexecuted bilateral contract for a true trust relationship to be seen as a gift or a donation from you on a unilateral contract. I guess we need to tell them sign the damn contract already. The New York Revised Statutes define a power to be an authority to do some act in relation to lands and creation of estates therein, or the charges thereon, which the owner granting or reserving such power might himself lawfully perform. So we want to revoke their power. They are powers of revocation and appointment which are frequently inserted in conveyances which owe their effect to the statute of uses. When executed, the uses originally declared cease, and new uses immediately arise from the person named in the appointment, to which uses the statute transfers the legal estate and possession. That's what they've done, man. They transferred the legal estate and possession to somebody else by some revocation and appointment, which are frequently inserted in conveyances which owe their effect to the statute of uses. When executed, the uses originally declared ceases, and new and immediate arise to the persons named in the appointment. Somehow we named them in the appointment, and now we just need to go revoke it. Probably much harder than it sounds, but at the end of the day, quit going to the courts, quit going to the register of deeds, quit going to the county clerk, quit going there and go to the executive and talk to him. Accept his oath and bind it to him. And tell him you revoke the state, county, whoever's authority over your property. Carry out my order. And that's just more, it goes on and on and on. There's just the never-ending list of definitions. Besides the personal remedies which an agent has to enforce his claims against his principal for his commission and advancements, he may lean upon the property of the principal in his hand. See, so somebody's got a $5 lien against us someplace. We need them to go get the books and settle the accounts. And the guy that can do that is the chief executive, maybe the county executive, but I think you go to the county executive first and let him figure out what to do with it. Or take it right to the governor, to the office of the executive. This is interesting. Authority. The right and power which an officer has in exercise a public function to compel obedience of his lawful commands. A judge, for example, has authority to enforce obedience to his not being correct. It's not that you're not correct. I just ain't going to do it anyways. He has the authority to enforce obedience to his not being correct. I don't think you want to go to the judge. You want to go to the executive magistrate. That says it all right there, man. I'm going to leave it there. See ya.